Speculative losses. As we have discussed, expectation damages include not only the loss in value, which is the difference between what an injured party would have received if the contract were performed, less the value of the defective performance, but also incidental and consequential damages, which are losses incurred in arranging a substitute transaction, and injury to person or property resulting from defective performance. However, as we discuss, those losses are limited by foreseeability of those damages and by the duty to mitigate those damages. Now we will discuss how those losses are also limited when they are speculative, hard to calculate. The second restatement of contract, section 352, states, quote, "Damages are not recoverable for loss beyond an amount that the evidence permits to be established with reasonable certainty." Damages are not recoverable for loss beyond an amount that evidence permits to be established by reasonable certainty. The restatement goes on to explain that courts have traditionally required greater certainty in the proof of damages for breach of contract than proof of damages for a tort. But why do courts limit damages in this way? Perhaps one reason is that courts do not want to award a windfall to a contract party, because breach itself is not wrong, and the party should not pay more than they had bargained for, and the party should not receive more than they bargained for. Windfall damages means damages in excess of what a party would have received if the contract were performed. And allowing windfall damages has the perverse incentive of encouraging parties to enter into contracts that they hope will be breached and not be performed. Moreover, the purpose of contract law, which is to allocate property to its place of highest value, will not be served if parties enter into contract not to get the property, but to get a chance at windfall damages that result when an unreasonably high amount of damages are awarded. There's also an argument that it would be fundamentally unfair to award windfall damages in contract breach because breaching a contract is not wrong or morally bad in the same way that committing a tortuous action is wrong or bad. And finally, perhaps courts do not award speculative damages to a contract party because, as we will see in the next part of our discussion, non-monetary damages such as specific performance and negative injunction are available when money damages are too speculative to calculate. So, now that we understand that courts will not award money damages when they are too speculative, when are money damages too speculative? The most common case is where a new business is the injured party and so has no track record. We don't know what type of profit a new business will make, and so if a new business is impeded from opening and doing business, how do we calculate damages? Imagine that Paula plans to open a new pizza shop on Murray Avenue, and Quincy agrees to lease the restaurant location to her. Paula gets a bank loan, hires employees, buys a grand opening sign, but when the time comes for the lease on Murray Avenue to begin, Quincy fails to provide the space. Quincy has breached the lease agreement, but what damages must Quincy pay to this new business that Paula was going to begin? A new business might lose money for several months or years, so traditional expectation damages, which are calculated on how much Paula would make if she gets the lease space versus how much she will get if she does not get the lease space, could actually be negative because she has been prevented from losing money with her foolish new venture. Paula could seek reliance damages for the value she expended on the loan, the employees, and the sign, and put her into a status quo position that she would have been in had the contract never been formed. But she doesn't want reliance damages. She doesn't want to go to the status quo position. She wants to be put in the position she would have been in had the contract been performed. Some courts will apply the so-called new business rule and find that expectation damages cannot be calculated when an entrepreneur has no track record of past profits. And so future profits that would have been earned but for the breach are too speculative. However, a court might be persuaded to award money damages based on other things, including comparisons to similar businesses nearby. It turns out that there are 3 pizza shops on Murray Avenue, and perhaps we can look at their profits to determine what Paula would have made had she opened a 4th shop. A court might award damages based on comparisons if they can show with reasonable certainty what the profits would have been had the breach not occurred. Still, it is quite likely that a court will not award money damages where a new business has no track record of profits. On the other hand, a court will be more willing to award expectation damages to a new business where there is evidence of average profits in that industry, comparable businesses that have a track record, and especially past profits of that particular firm in question. In short, the more a new business is unique, the harder it will be to analogize it to existing businesses, and the less likely it will be for a court to award expectation damages for lost profits, because lost profits of a unique new business will be too speculative to award. The limitation on the award of speculative losses is particularly problematic for new businesses, but it is always hard to calculate future profits with any certainty. Accordingly, courts are usually hesitant to award expectation damages for future profits without good evidence of what those profits probably would be. The best evidence can be a track record of past profits from the firm, evidence of profits from similar firms, or something else. But the key point is that courts will be hesitant to award expectation money damages for uncertain future profits. Fortunately, injured parties have access to other remedies in equity when remedies in law are not available. In addition to foreseeability and speculation, there are 2 more limits on expectation money damages that we should address: punitive damages and heightened damages at law in excess of an injury that a court might award to discourage breach. Punitive damages are heightened damages, which a court would award to discourage breach, and penalties, which are heightened damages that are in the contract, that the parties have arranged in advance to be paid in the event of breach. Courts will rarely award punitive damages or penalties, although they will often award something else called liquidated damages, which is the amount of damages called for in the agreement that are not for the purpose of punishment. So all these concepts need some elucidation, and we'll discuss them next: penalties, punitive damages, and liquidated damages. But before we move on to our discussion of punitive damages, liquidated damages, and penalties, are there any questions about limitations on speculative losses? Yes?